Hello, and welcome to this week's episode of the Illinois Appellate Roundup. We tackle recent Illinois appellate and Supreme Court decisions that represent important developments in appellate and post-conviction law. Whether you practice in this area yourself, or you or a loved one is facing an appeal or a post-conviction matter, I break these decisions down in plain English, what the court decided, and what it could mean for you. This week, three decisions that share a single theme. In a courtroom, choices have consequences, and the law holds everyone to their own moves. Our first case asks whether the state can tell a jury that a man refused to hand over his DNA and what happens when the defense itself opens that door. Our second follows $250,000 and a Lexus that the state seized and then tried to walk away from. And our third answers a question everyone who has ever signed a plea agreement should hear. If you withdraw your guilty plea, do the charges the state dismissed come back? For each case, I'll give you the holding, stated plainly, and the takeaway for your own practice. We begin in Kane County with a foot chase in the dark. Just before 4 o'clock on a November morning, two Aurora police officers noticed a black sedan they associated with a well-known local gang member. The car had a missing registration light, and when the officers tried to stop it, it sped off through a residential neighborhood, then stopped abruptly, and the front seat passenger jumped out and ran. Both officers noticed the same detail. As the man ran, he clutched the right side of his waistband, the way you hold something heavy that you do not want to drop. For 10 minutes, he led officers over fence after fence through dark backyards before he tripped and was arrested. His pockets held a phone, some charging cables, and a video game controller. No gun. But when an officer walked back along the path of the chase, he found one, a fully loaded handgun, lying in a fenced backyard directly along the route, perfectly dry, resting on top of the leaves. The homeowner testified that the gun was not there the evening before, when she let her dog out, and that no one in her house owned one. The man had two prior felony robbery convictions, which made simply possessing a gun a serious felony, armed habitual criminal. The trial turned into a fight about DNA. The gun had been swabbed for DNA, but the crime lab would not test those swabs without a comparison sample from a known person, and the defendant, when asked, declined to volunteer a cheek swab, as was his right. His lawyer made that missing DNA the centerpiece of the defense, telling the jury in opening statement, "The swabs were taken, and you will never hear the results. Ask yourselves why." The state answered the question. It put on testimony that the swabs were never tested because the defendant refused to provide his sample. The jury convicted, and the judge, after hearing evidence of the man's gang history, sentenced him to 10 years. Here is what the second district held, and every piece of it is instructive. First, the gun. No witness saw the defendant hold it, and no forensic evidence tied him to it. The court affirmed anyway, because possession can be proven by circumstances. A man running while clutching his waistband, a gun appearing overnight in a fenced yard directly along his path, dry on top of the leaves, in a yard that held no gun the night before. A rational jury could conclude he threw it as he ran. Second, and this is the heart of the case, the refusal. The court restated an important rule. Ordinarily, the state may not tell a jury that a defendant exercised his constitutional right to refuse a search. Just as a prosecutor cannot treat a defendant's silence as evidence of guilt, the state cannot invite a jury to convict a man because he declined to hand the police his DNA. Standing alone, that testimony would have poisoned the trial, but it did not stand alone. The defense had told the jury the results were missing and dared them to ask why. Having opened that door, the court held, the defense invited the answer, and a party cannot build its case on a door it opened and then complain on appeal about what walked through. Nor was it ineffective assistance of counsel, making the state's missing forensic evidence the theory of the defense was legitimate strategy. It simply carried a price. And third, the sentence. At sentencing, the ordinary rules of evidence are relaxed, and the judge was allowed to consider the man's documented gang history, his own past admission of membership, his associates, the colors he was wearing, in finding the offense gang-related. 10 years, in a range that ran from 6 to 30, was affirmed. And here is the takeaway. The missing DNA defense is powerful, and it is everywhere, because juries expect forensic proof. But this case teaches that it is not free. If you tell a jury the state has no DNA and dare them to wonder why, you license the state to explain, including with your client's own refusal. So make that choice deliberately. Either keep the refusal out by keeping that door closed, or open the door knowing exactly what will come through it. And remember two quieter lessons. A gun found along the flight path, fresh and dry, can carry a conviction without a fingerprint. And a client's gang file, even an old one, will be waiting at sentencing. Our second case has an unusual caption. It is called The People of the State of Illinois versus a 2017 Lexus and $250,000 in cash. And no, that is not a mistake. In a civil forfeiture case, the state does not sue a person, it sues the property itself, and the people who claim that property must step into the case and fight for it. This one began with a traffic stop on Interstate 70 in Madison County, across the river from St. Louis. Inside the Lexus, troopers found $250,000 in cash, concealed beneath the carpeting under the center console. The state charged the two men from the car with money laundering and filed a forfeiture case asking a judge to declare the car and the cash the proceeds of crime. The judge found probable cause, and the property went into an evidence vault. The men filed a sworn claim insisting the money was lawful, gathered, they said, from family and acquaintances to open a restaurant in the Midwest. The state moved to strike that claim, and then everything paused while the criminal case went first. 9 months in, the case took a turn. Prosecutors in Missouri charged the same two men over the same money and asked Illinois to hold the cash as evidence for them. And then Illinois changed course entirely. The state dismissed its money laundering charges and dismissed its own forfeiture case, telling the judge the money should simply go to Missouri. The judge signed the dismissal and washed his hands of the rest. Once the case was dismissed, he said, what happened to the property was not his concern. It would sit in a vault at the state police, and if anyone wanted it, they could go file a lawsuit. Here is what the 5th District held. It reversed. When the state seizes property, files a forfeiture case, and obtains a finding of probable cause, the court acquires power over the property itself, what lawyers call in rem jurisdiction, jurisdiction over the thing. And that power, the court held, does not evaporate because the state later changes its mind. It continues until the judge enters an order directing where the property lawfully goes. A prosecutor can dismiss his own case, but he cannot dismiss the court's authority over what is sitting in the vault, and he certainly cannot decide on his own that $250,000 should ride off to another state. The court also faulted a skipped step. Once the state challenged the men's ownership claim, the law required the judge to resolve that threshold question, who has a valid, lawful claim to this property, before disposing of the case, and that never happened. But the court was equally clear about what its ruling does not mean. The men do not automatically get the money back. The rule requiring return of seized property applies when the state tries to prove its forfeiture case at a hearing and fails. A voluntary dismissal is not a loss on the merits, and property can lawfully be held as evidence. Questions the circuit court must now sort out on remand, including what to make of Missouri's request. And here is the takeaway. If your client's cash or car is seized for forfeiture, understand the architecture. The court, not the prosecutor, and not the police, controls where that property ends up, and it cannot close the file without answering the question. So when the state dismisses, do not let the case quietly end. Insist on a disposition order, on the record, but prepare for the fight that actually decides these cases, the threshold hearing on whether your client has a lawful, legitimate claim to the property. Dismissal is not an automatic giveback, and the burden of showing a lawful source will sit on your side of the table. And for the state, the lesson runs the other way. The power you invoke when you seize property and file suit is the court's power, and you cannot switch it off by walking away. Our third case is about a bargain, and what happens when you tear one up. It comes from the 3rd District, out of DuPage County. On a March afternoon in 2019, a woman leaving a store in Bloomingdale was forced into her own car at gunpoint. What followed, an armed kidnapping, a sexual assault, a robbery, produced a 14-count indictment and a potential sentence that ran to more than a century in prison. On the eve of trial, the defendant made a deal. He pleaded guilty to 2 counts, and in exchange, the state dismissed the other 12. The bargain capped his risk at a fraction of what he had faced. And then, before sentencing, he changed his mind. Acting on his own, he asked to withdraw his guilty plea, and the court allowed it. Now here is the wrinkle this case turns on. The state never filed a formal motion to bring back the 12 dismissed counts. It simply proceeded, and so did everyone else, as though all 14 charges were alive again. His own lawyers filed motions listing all 14. The judge told him in open court that he had, quote, started over. 7 months later, a jury convicted him on 10 counts, and he was sentenced to 101 years. Years after his direct appeal failed, he filed a post-conviction petition arguing that he had been tried on charges that legally did not exist, that the 12 counts died when the state dismissed them and were never lawfully revived, and that his appellate lawyer was ineffective for failing to say so. The circuit court dismissed the petition at the first stage as frivolous. Here is what the Third District held. It affirmed, and its reasoning is worth committing to memory. A plea agreement is a contract. When a defendant withdraws his plea, the contract is rescinded, undone, and the law of rescission returns both parties to where they stood before the bargain. His pre-plea position was a 14-count indictment and a plea of not guilty. The state's pre-plea position was its full slate of charges. The dismissal of those 12 counts was not a gift. It was the state's side of a bargain that no longer existed. So when the plea fell, the dismissals fell with it. And the record, the court said, completely rebutted any claim of unfairness. For 7 months, every filing on both sides, and the judge's own words from the bench, told this man he faced all 14 counts. There was no surprise and no prejudice. A post-conviction claim that the record itself contradicts is frivolous, and an appellate lawyer is not ineffective for declining to raise an argument that would have lost. One more note, because the court took care to add it. The better practice, it said, is for the state to file a formal motion to vacate the dismissal and reinstate the charges, a caution that the informal route, though it survived here, is not the wise one. And here is the takeaway. For anyone weighing a plea, and for every lawyer who counsels someone weighing one, this case states the stakes with brutal clarity. A negotiated plea is a cap on risk. Withdrawing it does not return you to some middle ground. It removes the cap entirely, and every charge the state gave up comes roaring back. That is a decision to make coldly, with counsel, after doing the arithmetic, never alone, and never in frustration. For post-conviction practitioners, the lesson is procedural. At the first stage, the record is king. Before you build a petition on a claim, read the record against that claim, because anything the record flatly contradicts will not survive the 90-day screen. And for prosecutors, take the court's hint. File the motion and reinstate the charges formally. The next court may be less forgiving of the shortcut. So here is the thread that ties this week together. Each of these decisions is about a choice and about a court holding someone to the consequences of it. The defense in Kane County chose to build its case on the DNA the jury would never see, and that choice opened the door to the state's answer. The state in Madison County chose to seize property and invoke the court's power over it, and learned that it could not switch that power off by walking away. And a defendant in DuPage County chose to tear up the bargain that was protecting him, and the protections went with it. In each case, the appellate court applied the same even-handed principle. Your moves have legal consequences, whether you are the defense, the prosecution, or the person accused. For practitioners, the discipline is to make every move with eyes open, because every door you open is a door someone else can walk through. And for anyone facing an appeal or a post-conviction petition, this is why the record matters so much. An appeal is fought on the record of those choices, line by line, and that is exactly where a careful appellate lawyer earns his keep. Thank you for watching this week's episode of the Illinois Appellate Roundup. If you are in need of appellate or post-conviction representation, please do not hesitate to call me directly at 312-517-3877. I'll see you next week.